Final case this morning is People versus Gary Gilmore.
Good morning, Stephen Helton of the State Appellate Defender Office on behalf of Gary Gilmore. Mr. Gilmore really wanted to be here this morning, but he couldn't afford to take the time off work. I'm going to try to reserve 3 minutes of my time for rebuttal. Mr. Gilmore is asking the court to remand so that the parties' dispute as to the proper amount of restitution can be resolved based on the evidence, which is what the Crime Victims' Rights Act requires, and so does the new court rule. The government's asking the court to utilize a different concept of waiver in the context of errors that occur related to restitution than all other errors that might occur during sentencing. And the only reason that it's given for why the court should adopt this rigid, formalistic waiver rule is so that it can continue to enforce an invalid amount of restitution. But Mr. Gilmore's case provides a number of strong reasons why the court should acknowledge that the typical distinction between waiver and forfeiture applies to restitution. As a factual matter, Mr. Gilmore never intended to abandon his right to challenge restitution. When Judge Callahan held that he was not going to conduct an evidentiary hearing, his trial counsel made a record so that the error could be preserved for appeal. When his trial counsel failed to renew the objection and renew the request for an evidentiary hearing at sentencing, his appellate counsel filed an application for leave to appeal 2.5 months later, asking the Court of Appeals to remand and order Judge Callahan to conduct the evidentiary hearing. Neither the prosecuting attorney or Home Depot will be prejudiced or sandbagged by Mr. Gilmore's counsel's failure to object to at sentencing. The prosecutor was aware of the nature of the dispute at the time of sentencing, and he should have been aware of McKinley. The prosecutor's office filed a brief 2 months ago saying that they still possess all the same evidence that the prosecutor possessed at the time of sentencing.
Was the payment of the restitution, the $18,000 restitution amount, part of the plea deal?
It was part of the sentence agreement, which was voided, taken off of the taken off the table at a prior hearing.
Was the entire, I guess you call it a sentence agreement, he agreed to plead guilty in exchange for the dismissal of certain charges. There was payment of restitution, and there was a sentence component, right? There was I can't remember exactly what it was, a year in jail maybe?
A year in jail, 2 years probation.
And the judge came back and said, I'm not going to go along with the sentence component of this.
Correct.
So I guess but then they did go forward with the plea otherwise, right? The same charges were dismissed, the same restitution amount was ordered. I mean, am I wrong to conclude that only the sentence part changed, or why should I accept your argument that the entire plea agreement was, I mean, the judge did say the word stricken, but it doesn't appear that that's what happened, or that's what, I mean, let me say this another way. Is this how it ordinarily happens? I mean, in my experience, the judge says the focus is on the sentence, everything else sort of remains in place, and then if the defendant wants to go forward, they go forward knowing everything else is the same, but the sentence, all bets are off.
So I would.
So 2 questions. One, is that generally correct, my understanding? And 2, if it is, why should we think something different than that happened here?
I don't think there's anything that is typical about what occurred in this case. Usually when there's a Cobb evaluation or a sentence agreement and the judge isn't going to follow it, he tells the defendant, I'm not going to follow it. You have the opportunity to withdraw your plea or affirm your plea. The $18,000 restitution portion was part of the sentence agreement. It was under the sentence terms in the written plea agreement. The parties, the judge understood that Mr. Gilmore disputed that he owed $18,000 in restitution.
But he could, after saying he wanted a hearing, he could then agree to waive that by pleading guilty in agreeing to pay that amount, at least under current law, could he not? In other words, he could agree to pay more than he could have been ordered to pay if he were found guilty, right?
I think he could agree to pay more than he could be required to pay under law, but I don't think the judge could lawfully order him to pay more. And I
In
don't
this
think-
case, you're talking about this particular case, right? You're talking about Judge Callahan in this case?
Correct, yes. So, but in any event, the prosecutor didn't condition his agreement to withdraw the habitual offender status or to withdraw the charges on Mr. Gilmore's continued agreement to pay $18,000 in restitution. He understood that Mr. Gilmore disputed that $18,000 in restitution could be ordered, and he didn't say, yeah, I will dismiss the habitual offender when asked, but only if Mr. Gilmore continues to agree to pay $18,000 in restitution.
It's
So,
it's such a unique set of facts. It's hard to like keep it straight. But tell me why, if I'm thinking about this incorrectly. I mean, I hear you that at the original plea negotiations, the defendant didn't like the idea of paying the restitution, the sort of restitution outside of the offenses he was pleading guilty to. But Justice Viviano is correct that you could agree, in a plea agreement, a defendant could agree to pay more restitution than is acceptable based on the particular charges you plead guilty to. But we're agreeing here that the judge says the deal is off the table. It's off the table, and it's like a do-over. And in the do-over, we don't have any new objection from the defendant to, we have silence. Is it fair to say that there's?
I agree, there's silence. I
Okay.
think
So
for
how do you
him
think
to have
about-
actually, yes, for him to have actually waived the $18,000 restitution challenge, he would have had to have been advised that he was doing so, just as in any other waiver.
So the question is, how do we think about silence, right? And it seems to me that in the context of restitution, there are errors and there are errors. Like, for example, if it was just the defendant pled guilty to stealing a car, and the judge said, and the car, I find that you owe $5,000 because that's what the car was worth, and the defendant says nothing, and then on appeal says, hey, I should have had a hearing because I think that car was really only worth $4,200. That's different from a McKinley type error, which we have said it's legally improper to charge somebody for restitution for offenses that they haven't been convicted of. So do we think about those two kinds of silence on restitution objections differently?
I think it's, I mean, at most it would be unpreserved, right? The court had, since Carter and Karina has issued, the court has held that a number of errors that occur at sentencing that are not objected to, that results in a forfeiture, not a waiver.
We have, definitely. There's lots of cases where we've done that, yeah.
And that includes court costs, court fees, that even includes where a defense attorney says, I agree, the guidelines are correctly scored. That doesn't constitute a waiver. So whether or not the judge had to sua sponte, conduct an evidentiary hearing based on the dispute that was brought to his attention at the plea hearing, but was not re-requested at the sentencing hearing, we think it is, but it really doesn't matter to whether or not Mr. Gilmore is entitled to relief, because he can easily establish plain error under these facts. The crime of Mr. Gilmore's conviction, the conduct that resulted in his two convictions, is the conduct that occurred on March 22nd, which was he walked into a Home Depot in Novi and replaced the tag on a door mount and scanned a fraudulent UPC code, which allowed him to pay something less than the $160 or $199 that the retail value of the door mount. So, even if you accept that Judge Callahan was entitled to rely on the factual assertions in the pre-sentence report, the pre-sentence report makes clear that the most that could be ordered in restitution under McKinley is $199. So, for that reason, and I mean, clearly Mr. Gilmore's been prejudiced as a result. As a condition of his probation, he's being required to pay about 100 times more than could properly be ordered under McKinley, and the court should exercise its discretion and grant him relief. This court said in other other guideline errors that there's nothing more inconsistent with substantial justice than requiring someone to serve a longer sentence than is provided for by law. Mr. Gilmore's being required to pay restitution in great excess of the amount provided for by law, and if he doesn't continue to make those payments, he will be incarcerated as a result. And so we think, clearly under Karina's at least, the court should reverse and remand so that the proper amount of restitution can be determined based on the evidence. I will reserve the rest of my time. Thanks.
Good morning. May it please the court, Amanda Smith, Wayne County Prosecutor's Office, on behalf of the people of the state of Michigan, the appellee in this matter. I'd like to focus on the reason this case came on appeal to begin with, and it was defendant's original claim that he had properly preserved his objection to the court's restitution order. And the nature of that preservation, according to defendant, was the question raised by his attorney, Mr. Parker, on May 18th, 2016, when defense counsel asked the court, can we simultaneously accept the people's offer, which was a plea package with a sentence agreement and included an express term to pay $18,000 in restitution? Can we accept this deal and also have a restitution hearing? And the judge answered that question in the negative and said, you either take the deal or you reject it and go to trial.
What authority did the judge have to do that, to inject himself into the plea agreement in that way?
I don't view it as the court injecting itself into the plea agreement. The court did not decline to add a term to the people's negotiated package, which would have been to add a requirement that restitution be established at a restitution hearing under Siebert and under.
The judge is essentially saying, if I'm gonna accept your guilty plea, you're gonna agree to pay more restitution than I could order you to pay under law, or else I'm not accepting your plea agreement. It seems pretty extraordinary, doesn't it?
I'm sorry, could you repeat the question?
The judge seems to be suggesting that he would only accept the plea agreement that the parties entered into if the defendant agreed to pay more restitution than the judge could order by law.
It depends, I suppose, on really how this case could have resolved. So I agree under the way we charged the case. It was March 22nd, 2016, 4 felonies, 1 misdemeanor arising out of an incident that occurred in Plymouth Township, Michigan. I agree that that's how we charged the case, and if it had just gone straight to trial and there was a conviction on all counts, that Mr. Gilmore could only be required to pay restitution.
We have to deal with this case, right? Not the hypothetical case you could have brought on other charges and done things differently, right? We're sort of down the road.
But there's a reason why we offered the plea that we did, which was to have a global resolution of not just this case, but also to make the victim whole, for the entirety of the loss suffered by.
I get that, but your office, that wasn't the priority you were thinking of when you charged the case, because you didn't charge all the offenses you would have needed to make the victim whole had you been able to convict the defendant of all these charges, right?
Well, we didn't charge the case originally that way. There's no restriction under joinder rules, double jeopardy, or anything of the related sort that said that we couldn't add charges to encompass the entirety of the criminal scheme to compensate Home Depot in full for the losses in this case. This case was not going to plea out with an $18,000 restitution agreeable to be paid by the defendant. Then we would have charged and added that count and gone to trial that way.
In your view, the deal was contingent on the $18,000 being paid? The plea offer?
Yes, I mean, when Mr. Parker asked that question, we didn't decline to strike that provision from the agreement. That was the agreement that we offered, the resolution that we offered, and Mr. Gilmore did, after a brief recess, agree under oath to take the deal with that full restitution amount in the negotiated package.
Well, how should we think about, I mean, this is sort of we have to be careful not to let bad cases make bad law, but how should we think about the fact of defendant's silence and his counsel's silence in raising the restitution issue again when the trial judge essentially went crazy the first time the issue was raised?
Right,
Should that
aware of
impact
this
how
record.
we view the silence?
This is a difficult record. So sentencing is a different beast than other types of proceedings that happen in the trial court. Sentencing is prescribed by the court rule 6425 which are, promulgated by this court. The way that the court conducts a sentencing hearing is with that pre-sentence report, which the parties are entitled to have 2 days in advance. If they don't get it and they don't waive that time period, then they're allowed to ask for a delay in sentencing. The parties are given ample time to review the content of that report, and that is the material that the court uses in order to not just set the sentence if it's post, conviction by bench or jury, but also for restitution. The trial court judge doesn't know anything about the case when it comes to restitution. The court rule explicitly lays out under 6425A and B that the trial court judge gets that information about restitution from the pre-sentence report. And it's up to the parties. The parties are charged to challenge that information in the report. The parties either affirm that that information is correct, or any dispute will result in the court being required to have a restitution hearing. So I disagree that sentencing is just a mere silence. You could have a circumstance where a trial court judge erroneously never refers to the pre-sentence report and nobody ever brings it
Can I
up.
just interject for a second? In this case, I understand what you're saying. Most of the time, the judge learns about some details of the case they didn't know in the pre-sentence report, but clearly in this case, the key information about restitution was known to the trial judge in advance of sentencing, right?
It depends on, I guess, exactly what you mean by that. I know Mr. Gilmore originally on May 18, 2016, when he comes to that final conference and the plea offers put on the record, he's not crazy about the offer, but a lot of the times the defendants maybe aren't thrilled with the offer that we, provide for them. But what ended up happening? They go off the record, they come back, and he agrees under oath. He agreed to pay the money. So while I agree initially there was some resistance there, Mr. Gilmore eventually did plea in this case. So the idea that the trial court judge 28 days later when they come to sentencing we're supposed to remember that there was an initial hiccup basically before the plea went through, and that somehow acts to preserve a later restitution order. I just don't think that's really a credible argument, frankly, because the statute and the court rule prescribe that restitution orders are generated at sentencing, and at sentencing you have ample opportunity to object to the pre-sentence report, and that that is the material the court uses to generate the court's restitution order. And in this case, Mr. Parker, who is able to, as counsel for Mr. Gilmore, he accepted all of the information in the report, which includes an explanation.
In your view, the defense counsel should
restitution.
have raised the issue again, having raised it on May the 18th, and saw the effect it had on the judge's blood pressure. You think defense counsel should have raised it again on the 15th, the very day his client was going to be sentenced, and send the judge into the stratosphere again? That would be good
So,
advocacy?
right, I am fully aware of the trial court judge who dealing with this case and the record of May 18. It's not my favorite record, but it is the record I have.
And it's not, I'm not putting it on your side of the ledger
Sure.
either. It's the trial judge,
I
think.
understand the idea that, there's ideas in these different cases. It's a futile objection. You already got chewed out once. Why bring it up
It's
again?
worse than futile. It's not just that you're going to lose the motion or not get the hearing you want. It's that the defendant may go to jail or prison for a longer period of time, having angered the judge again on the same point at sentencing, right? Defense counsel has to be a little bit cognizant of the atmospherics, right?
But I do think that the question that was posed on May 18th is different from what occurred at sentencing. The question that was posed by defense counsel on May 18th was, can I accept the people's package offer and also have a restitution hearing? And the judge, he went off on why he thought that was wildly inappropriate to even entertain such a question. That is separate and distinct from counsel's duty at sentencing. He knows that the defendant's going to have to pay restitution. And if that restitution number is incorrect in the pre-sentence report, any objection under the statute requires a restitution hearing. There's never been an allegation that Mr. Parker was ineffective in this case.
But counsel, don't you think that really puts the defense attorney in like an impossible situation? Per what Justice Viviano was saying, I'm just putting myself in the position of a defense attorney. You could wind up in contempt. It just seems like it's kind of a tough ask that you're making per this judge's behavior, per the sentencing, putting this all together. It's kind of a tough request that you're making of any defense counsel to have to do that with the kind of judge that you're contending with, is it not?
Counsel is charged to follow the court rule, and even if he upset the judge on May 18th when they show up for court 28 days later. That original deal is thrown out.
And the judge was using profanity, which.
Yes.
I mean,
Yep.
I guess my point would be if I'm the defense counsel and the judge uses profanity, and now I'm going into sentencing, I'm just sitting here thinking, if I do this, I know what's going to happen. I know what's going to take place. Per Justice Viano's question, not only is it going to impact my client, I'm going to wind up being held in contempt.
I mean, counsel's-
Possibly.
Right. I mean, counsel can't just sit back, though, and speculate that there's a chance that I could get yelled at. If I say to the court, well, now I'm thinking that I need to object to restitution because we're no longer in that situation we were on May 18th.
Okay.
I mean, counsel's still charged with that duty to perform ably and competently for his client. And as I said, no one's ever filed anything in this case to allege that defense counsel was ineffective.
What about the idea that the plea agreement was stricken, and then when we're back in court now on the last court date, and the judge starts over and says, there's no deal, it's stricken, we're
Right.
done. It's, you understand. And so, if you maintain your plea, then the judge sort of goes through, having said that deal is stricken, starts to go through what the state of affairs is. You plead guilty, there's no sentence, you'll be sentenced, I think maybe he says within the guidelines, or at least pursuant to the guidelines.
Right.
But you'll also have these other charges dismissed. Okay, so that's the deal. Do you want to go with that deal? Yes.
Right.
Well, does the judge then have the authority to sentence the full boat on restitution? Where does that come from?
Right, well, that's why, so there's been some debate in my office about how I should be arguing this record. It's a very unclear record, because I think your question to counsel, the appellate counsel in this matter was, under 6310B, when the parties come to sentencing, the court can look at the sentence agreement and the pre-sentence report and say, I don't like this deal. That's functionally what happened on June 13th. I'm going to reject the sentencing
But
component.
the deal's not what's in the PSI. The PSI deal was based on the earlier deal. Now they come to court and the judge says, that's not the deal.
So there's
Here's
no
the
deal,
deal.
nothing's on the table. Nobody owes any promises anymore.
Right, and that's why I argued it the way I did in my brief. I feel like I have to be faithful to the record when the court was very explicit saying to Mr. Gilmore, you understand that May 18th deal is gone. He said, yes, I understand that. So I'm pretending that we're starting over. That's how I argued it in my brief. So I agree that there is no express statement in the plea as it arose on June 15, 2016, where Mr. Gilmore said, under oath, I will pay $18,000. But that information is in the pre-sentence report, which counsel affirmed was accurate, and there was no objection on the record at sentencing after affirmation of the pre-sentence report. There's no post-conviction motion to correct an invalid sentence. There's no motion to remand. And under 769-3410, information that the court relies on at sentencing to generate the sentence, that's how you preserve those objections, and that's beyond my waiver argument. But that never happened in this case. The first time
We would not look to the PSI in an ordinary case as informing or adding a term to a plea agreement that's not stated on the record, would we?
Especially in light of a court saying there is no agreement here, right? Wouldn't we
Right.
take the court's words over?
Yes, so the court is just left with, we have the plea, we have the sentence that the court says you get a guideline sentence, but then everybody knows it's in the statute, court rule, and constitution, the victim is going to get restitution. Where does that number come from? It comes from the pre-sentence report, because the court doesn't have independent knowledge of the restitution that's due and owing to the victim under the Crime Victims' Rights Act. And that information was verified by Mr. Parker at that June 13th hearing. He indicated that the information was correct, and it indicated that a restitution is due and owing at $18,000. And that's how that amount got ordered at the June 15th sentencing hearing.
And if the defendant had stolen a car that was, the Blue Book value was $18,000, and the judge said, and the defendant didn't object at all, I would think you'd have a pretty good argument that the defendant wasn't entitled to any additional fact-finding on that. But here we have the court issuing an order of restitution for a scope that is not legally permitted per McKinley.
I believe that there's a McKinley issue, and so, again, I'm going, for the waiver argument, it's because sentencing is different than other types of proceedings. You have the restitution amount is obtained from by the trial court from that pre-sentence report, which the defendant can either dispute and get a hearing, or he can affirm the accuracy of that information, and that's under People versus Grant. The court can then rely on that number and generate its order. That's my waiver issue, my waiver point right there. But if the court does not find a waiver and the Court of Appeals did, but if the court disagrees, then we get into plain error. And I freely admit, under this June 15th record, we do have a McKinley issue. I mean, absolutely we do. So there's your plain error, but then we're getting to, the fourth prong, basically actual innocence, or, it's harmful to the administration of justice. And that's where we would ask that the court not reverse on plain error grounds. But I completely agree. There is a McKinley issue. This is a very cumbersome record. Every time I look at it, and I've been in the case for 2 years, I'm thinking, man, it just gets more complicated the more you look at it. But I agree with you on that point. I'm not sure, do I have time?
You have 4 seconds.
4 seconds. Well, thank you so much this morning.
Thank you very much. Counsel, why is the prosecutor wrong that you lose on prong 4 of plain error?
Because Mr. Gilmore is actually innocent of causing about $17,600, $800 of dollars in the damages that gave rise to his convictions. He hasn't been charged with or convicted of the other 51 transactions, and he's specifically denied taking part in 50 of the 51 uncharged transactions. So he is actually innocent of that. And in addition, he's being required to pay what is clearly an improper amount of restitution that the prosecutor should have known was invalid under McKinley, since it had issued 2 years earlier, and the judge should have known he couldn't order. His attorney asked the court to ask the judge to conduct the restitution hearing, and the judge erred in holding that he wouldn't conduct the hearing because 780, 7674 is mandatory. So even if the parties have a plea agreement that specifies an amount of restitution, the trial court is required to conduct the hearing if it's requested by the defendant. And the prosecutor was willing to accommodate that request by presenting evidence in support of the proper restitution number. It was only Judge Callahan that said that this number is fixed, and it was not because he respected the parties' plea and sentence agreement. It was because he had a misunderstanding of the law. He thought that the prosecutor would be required to prove beyond a reasonable doubt the restitution figure at trial, which is clearly not the case, and so we do think that Mr. Gilmore's liberty interests are at stake, certainly because of this, because he's been ordered to pay $18,000 that he doesn't have, and that he didn't contribute to causing and so for that reason, the court should exercise its discretion. Just a couple other things regarding the Mr. Gilmore's counsel's acceptance of the pre-sentence report. The pre-sentence report contains factual information that I guess the court could continue to agree a defendant is bound to unless he files a motion to correct the sentence. But the judge isn't entitled to rely on erroneous legal conclusions by the probation officer. So when the probation officer says that restitution is appropriate at $18,000, but the facts asserted in the pre-sentence report show that restitution should be ordered at something like $200, the judge needs to understand what the law is because the probation agent isn't a lawyer. It's not clear how Gahan and Grant's waiver rule works under the current version of the Crime Victims' Rights Act. Especially considering 780, 766-22 allows the defendant to provide new or updated information about the victim's damages at any time after sentencing. So Mr. Gilmore sought to present evidence about the damages caused to Home Depot at sentencing. He wasn't permitted to do so. There's no cognizable way of saying, well, now he can't present that evidence to the court because the statute specifically allows him to, and so does the court rule, the new court rule. And so,
why do you say at sentencing he wasn't allowed to?
He requested at the plea hearing to have the.
But he didn't request it at sentencing.
That's true. And that's why at worst we say that this is forfeiture.
And didn't the judge at least a little bit back off by asking the prosecutor, what would you have to say about this? And the prosecutor articulated, what he thought the proofs would show. And it sounded as if, if there was a hearing, that this is what would be presented.
My reading of the plea record is that the prosecutor agreed to have the amount of restitution decided based on the evidence. The prosecutor didn't indicate that the offer is firm, it's $18,000 or nothing. He said, I'll contact my supervisor, we'll get the receipts, and we'll see what it is.
And the judge wasn't hostile to that.
Pardon?
And the judge was not hostile to that.
No, in fact,
Initially he was hostile, but then after asking the prosecutor about it, he seemed to back off of that.
I would disagree with that. The prosecutor agreed to present this evidence and argument, and then Judge Callahan said, you have to take the plea now or forget about it, go to trial. And so that wasn't a valid
Just so we're
choice.
clear, he said, I'm not going to hear a cockamamie bull story from you. I wouldn't give you one, Your Honor. Okay, well, then you've got to fish or cut bait today, my man. My dad used to use another expression.
Yes.
So it sounds like he was still expressing some hostility to the defendant.
And so I think Mr. Gilmore
that
was,
point.
whether or not he was aware of it, was expressing the concerns of McKinley. And, Judge Callahan should have been aware of that holding.
Pretty clear
And-
he was not amenable to having a restitution hearing in this case on the record that was presented.
Pardon?
Pretty clear he was not amenable to holding a restitution hearing in this case on the record that, I don't know how he could have made it any more clear.
I agree with that. Thank you very
counsel.
much.
We appreciate it. The case will be submitted, and that concludes the morning's call. We'll return at 12:15.